Thank you very much for joining us today for our first Thursday Club of 2022. I'll just allow a minute or so for a few more people to come in. We've got a huge number of attendees today, and people are still joining us. But while we're waiting, I'll just introduce myself. I'm Stephanie Ray from RSK. And our speaker this morning is Dr. Tim Hounsome, who's the Managing Director of RSK Biocensus. And this morning, Tim's going to be talking about a class act, changes in environmental legislation relating to the new Environment Act. So thank you all very much for joining us. Before we start, we've just got a little bit of housekeeping to do. You'll notice when you join that your microphones are automatically muted, and we'll keep them that way throughout the presentation today. If you have questions, then please add them to the questions box, and at the end of the presentation, Tim will answer as many as we can, and if there are some that we can't get to, then we'll try and contact you separately with them, if indeed we know the answers. Shortly after the presentation ends today, you'll receive an email with a short survey. It will only take 2 or 3 minutes to complete, and it would be really helpful if you could do that for us to give us some feedback so that we can help to shape future webinars that we do in this series. So I think we're all about here now. And so with no further ado, I'm going to hand over to Tim and say thanks very much. Tell us about the Environment Act.
Thanks very much, Steph, and hello, everybody. I suppose I should also be saying Happy New Year. Is this the first Thursday meeting of 2022? I have to pause to say that. Well, as you can see, and as Steph's just said, I'm going to be talking about the Environment Act that came into being as a nice new shiny piece of legislation in the environmental sector in the back end of last year. I'm going to start with a disclaimer. I'm not a lawyer. I haven't helped draft this legislation. I'm an ecologist, and what I'm going to be presenting today is very much an ecologist's view of the Act as it appears. Obviously, I feel sort of duty bound to say that none of this is going to be legal advice. And you certainly wouldn't say that from an ecologist, especially not even an ornithologist. My view on the Environment Act is, and I guess would always be, that of an ecological consultant. I run a large ecological consultancy business and have been in and around conservation and the ecological world my whole career, which is longer than I'd want to admit. but let's just say when I started, there weren't any mobile phones. Working at night on your own by water was considered safe as long as you could hold your breath. A little egret for something that a twitcher would get out of bed for. Times have changed. As a result of my career and my work in the ecological consultancy world, I've obviously been hugely invested in this subject, and I've watched developments keenly for the last few years. What I'll be presenting today is a bit of a background to the Act, to put it in the historical context of why it actually came into being in the first place and why we needed it, in my view. I will then run through the structure of the Act, how it's been laid out, and then identify the key parts of that Act. Now, bit of a spoiler alert, the first bit is the creation of the Office for Environmental Protection, and obviously I'll talk about that in detail. But after that, other parts of the Act deal with specific environmental areas such as nature and biodiversity or water and so on. So I'll talk about that. But just to reiterate, I will be pulling out bits of the Act that I think are relevant from an ecological consultancy point of view, and I hope that you as an audience will identify certain elements that are relevant to you, and maybe then you can follow up and go and specifically look at those elements of the Act and do your own research. Obviously, then I'll end with a summary. So why a new Act? I think the first thing to do is to put this in historical context, and this is important to understand where we are now. Throughout my career, the influence and presence of the Wildlife and Countryside Act has been massively influential. This landmark piece of legislation arguably laid the way for the birth of the ecological consultancy sector as we know it. As a result of the Wildlife and Countryside Act, suddenly people, businesses, other entities were legally obliged to do certain things in a certain way, and if they didn't, they would be guilty of an offence. And obviously, this worried them, and they went around trying to find people that could help them. And generally speaking, they were looking at naturalists and academics, people that understood how to count butterflies or identify protected habitats. And gradually over that time, since the early 80s, these naturalists and academics have morphed into ecological consultants. I guess you could argue that some more readily than others, and in fact I know a few that are still morphing. The Wildlife and Countryside Act, of course, wasn't the only legislation that was influencing how species and habitats were protected in the UK, or rather the environment. From the 1970s onwards, the influence of the European Union on our environmental law has been profound. For example, the Waste Framework Directive, the Birds Directive, obviously as an ornithologist I was going to mention that one, Habitats Directive, and that's just to name but a few. In addition to the European Union's influence on the drafting of UK legislation, it's of course been sitting there as an arbitrator, as a final decision maker, as the headmaster almost. And so therefore most of our case law in the UK is also influenced by the decisions from the European Court of Justice. This in turn has had significant influence on the way we go about our work in the environmental consultancy world. I mean, how many times have we said as consultants, or perhaps have heard as a client, that we do things in a certain way because of such and such a case? The example the ecologists often quote is the case from Cheshire, where we were not required to have bat surveys to consent a project. And that was overturned, and it was said that in order to consent a project, you needed the full information and data before that application could be determined. I think it's fair to say that recently much of our environmental legislation and certainly our wildlife protection is starting to feel, if not appear, not quite fit for purpose, a bit tatty, been around too long maybe. I don't know. As we all know, the statute book doesn't change very rapidly. It is and has always been glacial in its movement, but also glacial in its influence, of course. But while we're adding to and tweaking and occasionally redrafting legislation, the world, or rather the globe, is changing rapidly. This has, as I'm sure we all know, culminated in the twin emergencies of climate and biodiversity. This may be going a bit too political, and it's hard to talk about an act of parliament without having a political slant on things, so forgive me. But I do feel that however well-meaning and however much passion and science and political will to change and avert these situations that was applied, our track record in this field is rubbish. On our watch, things have got dramatically worse. However, over the last few years, I've been encouraged, and I think there has been a clear and obvious step change in where the environment sits on everybody's agendas. I mean, not just conservation and environmentalists, but politicians, the man in the street, people that are now aware of things like biodiversity and environmental damage and climate change. I think probably at the moment, arguably it's only second to COVID in everybody's agendas. And, you know, speaking as a conservationist, as an environmentalist, this is great news. You know, about bloody time. Let's just hope it's not too late, I guess. But I do think finally the penny is dropping. So looking specifically at the UK, whatever the legislation the UK or the European Union derived and we'd legislated for, obviously hasn't worked. The Farmland Bird Index shows dramatic falls in species and abundance. Many, if not most of our rivers are polluted. The air quality in places in the country is worse than it ever was. Effluent discharge from water treatment works is at critical levels. As much good as our laws have done, they simply haven't done enough. That all sounds quite negative, I realise that, but here we are with this underperforming and not fit for purpose statute book, a twin global crisis of climate change and extinction rates, and at the same time, we're walking away from the organisation that has given us much of our environmental legislation, and even more critically, held us and our governments, importantly, to account. One might see this in a doom and gloom way, and many do, I can assure you, or you could see this as a perfect storm, as a once in a lifetime opportunity to get ahead of the game. Personally, and if you forgive me, I think I'm in both camps. I will always remain cynical of politicians and politics. I think that's a healthy place to be. And the UK government not being held to account by a higher authority, such as the European Court, really worries me, as it does many others. But on the flip side, I think I will also admit to a certain sense of freedom and opportunity that this gives us as a nation. We now have the opportunity to draft and enact legislation that means that it paves the way for us tackling once and for all the way we use and interact and leave our environment. There have been, as one would expect, a number of political statements on this, and strange as it may seem to some, we are indebted to Mr. Gove for some of the initial influence here. In the preamble to the Act itself, it states that the aim of the Act is to introduce groundbreaking new legislation with the objective of being the first generation to leave the environment in a better state than that in which it was found. There was also this tacit reference to Brexit with an express purpose of ensuring there was no environmental governance gap. So that's the background. What is the Environment Act and what does it cover? First thing to say is that in order to pull all this information together for today, I'm indebted to a host of articles, websites, etc. My intention isn't to go through the Act line by line, cue collective sigh of relief, but to pull out key points. And I will say again, key points to me as an ecological consultant, which hopefully will resonate with you. This isn't supposed to be a full analysis of the Act. So some facts about the Act itself. I mean, it had a very long, protracted journey through Parliament. It took over 3 years from its initial conception in 2018 and to get its royal assent in the back end of last year. I guess to a certain extent this was probably influenced by COVID, but I think also it was a heavily debated and contentious bill, and quite rightly. And so I think as I go through my talk, you'll see elements of amendments that were tabled that have actually strengthened the Act as it turns out. It went through 3 parliamentary sessions and had was in 2 Queen's speeches. Just quickly look at the structure of the Act. It's deceptively simple, as all these things always are. It's laid out in 8 parts. There was 149 clauses and sections within the Act, and then at the end there is 21 schedules that are appended to that. What I'm going to do now is go through these various parts, although I will be missing out a couple. The first point I'd like to make is I'm not going to be talking about Northern Ireland in this particular case. I think, as far as I understand it, currently it still hasn't been passed through the Assembly, and the miscellaneous is what it sounds like, and I'm not going to be talking about that today. Okay, let's talk about part 1, environmental governance. For reasons I've already mentioned, this is a critical part of the Act. I don't think I can underestimate how important this bit was, considering what was happening with regards to with Brexit and so on. So with no higher authority to answer to, well, apart from arguably the people or the electorate, it's always been crucial that the Act set out how this would be achieved, how the absence of the European Court would be dealt with. And again, we have Mr. Gove to thank for some initial statements that set the tone. He said that he wanted a world-leading body to give the environment a voice and hold the powerful to account. And furthermore, that it would be independent of government and able to speak its mind. I don't think anybody can argue with that at this stage. I think that's a critical part of this organisation. A key element of the Act is the requirement to establish the Office of Environmental Protection, or the OEP. The political rhetoric around this Act has been concerned very much with its remit, the powers that it holds, how it's funded, how independent it's going to be. It is stated that its principal objective is to contribute to environmental protection and the improvement of the natural environment. Although the word contribute might sound a bit weak to some, as opposed to enforce or ensure, in theory, the OEP has the ability to hold anyone to account, including public bodies and, in theory, government. Many consider its ability to do the latter as a critical power when replacing the role of the European courts. There has been some debate around whether the differing levels of evidence needed to uphold an accusation of non-compliance are relevant. Under EU rules, a state had to have made or been found to have made a manifest error in its assessments. From now on, we will almost certainly now rely on judicial review, and many commentators have suggested that this approach is less evidential and therefore perhaps arguably weaker as a result. The OEP can receive and investigate complaints of serious breaches of environmental law by public authorities, including local authorities, government departments and arm's length bodies. And it can also take legal action if necessary. After its establishment, its first job is to prepare a strategy that will be presented to Parliament. And the OEP will also advise on changes to environmental law or other matters relating to the natural environment when requested by the Minister. The OEP will be required to draft an Environmental Improvement Plan, or EIP. Currently, the 25-year Environment Plan from DEFRA will be used as an interim improvement plan. But then subsequently, all EIPs will be reviewed every 5 years, and with each one setting out a 15-year improvement plan. I'd like to point out at this point that the longevity of some of these targets is significant, and it runs throughout the rhetoric within the Act. I think, speaking for somebody that used to work in the civil service, that this is encouraging. It could be considered as kicking into the long grass, but I think actually it's an acknowledgement that the solution to this isn't in the life of a parliament or in the life of a government. It's not 3 or 4 or 5 years. It's not somebody coming in and make a big splash to solve the problem, that this has to be the long-term view. So I'll give them the benefit of the doubt on this, but you will see as we go through this that this is a common thread. This commits the government to setting at least one new long-term binding target in each of the 4 areas: air quality, biodiversity, water and resource efficiency, and waste reduction. The Secretary of State must compile monitoring data to show whether the environment is improving in accordance with the EIP and the progress towards those targets. They must also report annually to Parliament on the progress of implementing the EIP. Part of this plan will set these targets, but they will have targets of no less than 15 years. And again, this is the longevity I was talking about. The theory, I guess, is to reassure people that they have a longer view than is normally applied in Westminster. They can, however, set interim targets, but there will be no obligation to meet these. This is the first in my head. This isn't the first slight alarm bell, but I'm going to go in with an open mind, I guess. Government ministers and public authorities will have a duty to have due regard to a policy statement, which will set out the 5 environmental principles in more detail. These principles will cover the principle that environmental protection should be integrated into the making of policies, the principle of preventative action to avert environmental damage, the precautionary principle so far as relating to the environment, the principle that environmental damage should, as a priority, be rectified at source, and the polluter pays principle. Those of you that have been working in the environmental sector for the last 20 odd years will recognise some of the words within this, based on some of the EU directives and case law. The bill also requires ministers to publish a statement before the second reading of any bill that contains environmental law provisions, and to state that in the minister's view, the bill will not have the effect of reducing the level of protection provided by any existing environmental law. The minister's view. Interestingly, there has been some movement on this area during the drafting, with changes in language, as you can imagine. There was 2 significant ones here that were removals of clauses that said that the principles would only apply, but wouldn't if they were not relevant to policies. Also, if applying the environmental principles to making, developing or revising the policies would have no significant effect on environmental benefit. Remember, these were removed. And then there was this capsule that sort of, if all else fails, we can get out of jail. And the clause again was removed, which was that They don't apply if any other matter specified in regulations made by the Secretary of State. So I think important emissions and removals. Just before we move on, though, there is an important point here, which is that there is exemptions under this the jurisdiction, and that is for the Ministry of Defence and the Treasury. I guess you can see reasons why potentially the MOD. I'm less sure about the Treasury, and I think we should be watching that carefully over the coming years. Okay, so that was part 1 of the Act, which covers the Office of Environmental Protection. I've skipped part 2 because that was, if you remember, to do with Northern Ireland. On to part 3, which is to do with the waste and resource efficiency. The main point here, I think, is a truly significant step change in the emphasis. Before, the waste was the problem of consumers, but the emphasis here is very much placed on the fact that the issue is with the producers. It would appear on the face of it that the Act will force manufacturers to take responsibility for the full life cycle of the products they produce. Powers derived through the Act will allow for extended producers' responsibility, or EPR, to allow the current 10% that is currently paid by producers to increase hugely to account for the true cost of what they're producing. In addition to this, we will see a return, and there's no pun intended, and you probably have to be a certain age to get this, a return of the Deposit Return Scheme, DRS, for empty drink containers. A deposit management organisation, DMO, and here we go with the creation of acronyms and abbreviations, will be set up to administer the scheme, and they will target 90% of all drinks containers to be collected via the scheme. Retailers who sell drinks containers covered by the DRS will be required to ensure that the deposit price is added to the purchase price and to accept all DRS containers returned to their store. They will need to host a return point, such as a reverse vending machine, it sounds like it's out of Douglas Adams' book, or a manual return point. This will be paid for via a handling fee to the DMO. Another clause allows for mandatory tagging of waste, or electronic tagging. This will replace this slightly archaic system of waste transfer notices that are sporadically followed up. There will be increased powers to charge for single-use plastics, as well as proportionate and effective enforcement against littering. Although I'm not really quite sure how that would work, and I can only imagine. Most importantly, the Act introduces powers to stop the exports of plastics to non-OECD countries, something that I personally think has been shameful of us in the past. Manufacturers produce unrecyclable packaging will have to pay higher fees. In addition, producers will have to clearly label packaging. The current estimate of the extra cost of packages is likely to be more than £3 billion. Part 4 deals with air quality and is a significant element to this Act. On a national level, the government's air quality strategy will have to be reviewed within a year of the bill coming into force, and then at least every 5 years thereon. The Secretary of State will be required to deliver an annual statement to Parliament outlining progress made towards achieving air quality standards and objectives. The government will have to set a legally binding target for particulate matter, and there will also be an as yet unspecified air quality target set for at least 15 years in the future. That number again. Through amendments to the Clean Air Act of 1993, English councils will now be able to issue fixed penalty notices for breaches with fines between £175 and £300. But the Act also empowers the government in order to be able to order vehicle manufacturers to recall non-compliant machinery. Part 5 covers all things wet in water. There are some fundamental changes in this area, and it's arguably one of the most significant victories of the tabled amendments throughout the passage of the bill, which I'll come on to in a sec. As mentioned previously, there's been justified criticism of the amount of sewage that is legally, believe it or not, discharged, as well as obviously the illegal discharges. I think, personally, this is a great example of where the current system really isn't fit for purpose. The legislative framework we have at the moment allows this to happen. That just seems wrong. The big one here is that the Act will make drainage and sewerage management planning a statutory duty on those companies that have the responsibility for these functions. Another significant change is in the ability of the Environment Agency to revoke abstraction licenses without compensation, even for long established rights. However, it would appear that these won't be enforced until 2028. Going back to long-term binding targets for water, it would appear that the reduction in phosphate and nitrate loading are to be targeted. And I think those that are joining us today that are building houses anywhere near SPAs in water catchments won't be surprised by this. And the direction of travel by a lot of policy has been very much in this direction anyway. Further to this, there will be targets set for the reduction in water use and demand, which presumably has added benefits such as a drastic reduction in carbon use. During the passage of the bill, and I'll talk about the amendments now, there was an amendment tabled by Philip Dunn, along with a few others, and as a result, some truly significant changes were made to the draft bill. These included a new duty on government to produce a statutory plan to reduce discharges from storm overflows. Government also has to produce a plan to describe actions that would be needed to eliminate discharges from storm overflows. And furthermore, there will be an obligation on the Environment Agency and water companies to publish data on storm overflow operation on an annual basis, and new duties on water companies to publish within 1 hour on the operation of stormwater overflows, and a new duty on water companies to monitor upstream and downstream of storm overflows and sewage works. I must admit, I wasn't aware that that wasn't already being done, and it seems a bit bizarre that it wasn't. Great that it's in the Act. Okay. Part 6, nature and biodiversity, and you'll forgive me for dwelling a bit more on this than some of the other areas, but I'm sure you'll understand why. The headline here is that the Act commits to halting species decline by 2030. Big cheers. This has been, and I'll try and remove the cynicism from my voice, but this has been a massive win for the Act. And I guess the devil is always in the detail. And we have heard about these sort of targets before from various organisations across the world. But, you know, it's a great point to start with and an ambition. On the face of it, the Act expands the existing duty for public authorities to by asking that they enhance biodiversity. This enhancement or net gain is a common thread running through a lot of policy and NGO rhetoric at the moment. And let's face it, if this Act is going to achieve its objective of leaving the environment in a better state than that which we found it, net gain is the only way forward. One slight issue is that the Act specifies that authorities apply the enhancement only to such policies and specific objectives as the authority considers appropriate. But to me, that's another warning sign and something to watch. The language is a bit too loose, I think, from my personal point of view. Okay, so biodiversity net gain. This is much talked about element of the Act, and well, at least in the ecological consultancy world. The Act is going to mandate through secondary legislation a requirement of all developments consented under the Town and Country Planning Act and those of nationally significant infrastructure projects, so pretty much all developments, a requirement to produce and demonstrate a 10% net gain in biodiversity value. For the first time, these will be legally binding agreements, some of which may be delivered through conservation covenants, which I will talk about in a minute. I think that from here, there's going to be a step change in the way all schemes from small house builders of 2 or 3 homes all the way through to master planning for new towns. There's going to be a step change in the way that this is approached with a view to enhancement. The encapsulation of the principle of enhancement is key to leaving the country in a better state than which we found it. The measurement of biodiversity is currently done via an assessment of habitat. And again, there has been much debate over whether this is a good metric to use. One thing is clear though, I think, is that it's fair and it's transparent and there's a level playing field, which I think is important from the industry adoption point of view. And to be honest, let's face it, anything that was going to try and assess biodiversity value was always going to be up for debate. There will be various options open to developers, from on-site gain through to offsetting via registered schemes or by purchasing from government. It's likely that this last option will prove expensive, and therefore I think we're predicting an emerging market in habitat banks and other landowners offering their land as areas for biodiversity enhancement. And to a certain extent, we've already seen movement in this area. Currently, the DEFRA metric, we're on version 3 at the moment, penalises offsetting of schemes that are geographically removed from the development. The idea is to prevent people offsetting miles away from where they're doing the works and making their offset less relevant to that particular impact. At the moment, if you want to offset off your site within the local authority where you're operating, and you have, say, the need to offset 10 units, biodiversity units, then that you will have to find 10 units within that local authority. If you go to the authority that's neighbouring, so next door to where you're doing the works, then you will have to multiply that by 0.75, so your 10 units become 15. And if you go further away than the neighbouring one, all the way up to miles and miles away up in North Scotland or whatever, then you have to multiply your need by 0.5, so your 10 becomes 20. My personal view is that the economics of land prices and the differential between, say, the north of Scotland or the Isle of Mull compared to Essex or Kent or somewhere in the southeast will mean that actually it still might be worth offsetting further north. So my personal view is that will have to change in order to maintain the principle that the offset is as appropriate and as local as it can be. There is, however, very little resource currently within the local planning authorities to effectively enforce their statutory requirements as it is. They have currently, 1 in 3 local authorities have an ecologist. I would worry that they're going to have the capacity to enforce this. There will be a new duty on public authorities to have regard for the conservation of biodiversity and a requirement to produce, publish and report on their plans to do so. Further to this, a key element to the Act is to require local authorities to produce local nature recovery networks in support of the government's ambitions to create national nature recovery networks. It will insist that local authorities will have regard to these strategies. How this will be reviewed and assessed is still not clear, but the principle is one of a more strategic approach to species and habitat conservation. The so-called Lawtonian principles will apply, the bigger, better and more joined up. An area that's still fairly unclear is that around the remit and powers of Natural England. According to the text of the Act, Natural England will have powers to introduce species conservation strategies, for example, and these would be similar to district licensing approach, although the details of this remain unclear. For those of you that live in Sheffield, there was also, you might be interested to hear that there's also a duty on local highway authorities to consult with local communities before felling street trees. We also see here a tacit acknowledgement that we don't protect the world by being an island. And this is, I think, quite a significant piece of the legislation and maybe a marker. It isn't going to solve the whole problem, but it's a marker and a good start in my view. But there is a new due diligence duty for large businesses to ensure forest risk commodities are not contributing to illegal deforestation and the destruction of rainforests. A cynic might, if you were speaking to one, point out that much of the world's deforestation isn't actually illegal and that most of the deforestation is happening legally within that country, but it is still deforestation. But I guess, like I said, this is a start and something that probably should be welcomed and built on. So how will this affect developments in England? The Act is going to have a significant effect on all developers in England and possibly Northern Ireland. All developers will have to show how they are going to achieve a net gain in biodiversity as a result of their scheme. But not only that, but demonstrate that this gain will exist for at least 30 years. I don't think this is going to be easily achieved. And I'm not sure many developers of house builders or even large tier 1 contractors are going to want a liability of 30 years. One option is conservation covenants, which I'll mention in a minute, but it's probably worth pointing out that most permitted developments and small householder applications are going to be exempt from the biodiversity net gain. A significant change from the point of view of an ecologist is the Act forces councils and developers to follow the mitigation hierarchy. Although in practice, this is already followed, but the basic premise of off-site mitigation enhancement is that it is the last resort. So conservation covenants, I'm just going to briefly talk about this. They're not a new thing. They've been in place for quite a while. Certainly if you've been operating in and around SACs in the south of England, there is many conservation covenants applied to homes when you buy them. The difference here is that the Act sets out specific ways that these will be enforced and ensure that all conservation covenants will be voluntary but legally binding, and that's a big difference. In addition, the covenant applies to the freehold, the title of the land, and therefore will be passed on through sales as opposed to being applied to the individual. Of course, there is an intrinsic link here between conservation covenants and biodiversity net gain, and the covenants are just one way that biodiversity net gain can be achieved for the long term. Again, this reference is running through the Act, the long term. My final point here is to say that this is brand new, not tested legislation. Any view of its value and the consequences is to a certain extent always going to be an exercise in crystal ball gazing. I, for one, will be watching the inevitable test and case law that comes from this with great interest. The government has referred to the bill as a landmark and world-leading legislation that will transform how we protect and enhance our environment. It sets out a comprehensive and world-leading vision to allow our environment to prosper and for the future generations, and to ensure that we enhance and maintain our environmental protections. There is a clear sense here of longevity, of a long-term view and strategy. For someone that has observed too many environmental policies with too short a time view, this is welcomed. Again, however, we must ensure that the pressure to deliver is high and constant, so that these long-term goals aren't a way of kicking the issue into the long grass when it becomes politically expedient to do so. The establishment of the OEP is arguably the most significant consequence of this Act. Whether it will have the independence and teeth that Mr. Gove imagined remains to be seen. As I said at the start, this situation represents both a huge risk as we leave the governance of the European Court, and at the same time a huge opportunity, a once-in-a-generation opportunity to develop a truly world-leading framework for the management, protection and enhancement of the environment. There is currently some justified concerns that despite the rhetoric, that there is still a governance gap in our environmental protections post-Brexit. And certainly not having recourse to a higher independent authority worries me. I guess time will tell if this is truly a landmark and world-leading piece of legislation, and whether in years to come we'll look back on this time as the time we made the big positive step to reverse forever the damage that we had done. Thank you very much. I'll take questions.
Thank you very much, Tim. Excellent. Can we see you again? There we are. Perfect. Well, we've got quite a few questions and not very many minutes left, so I'm not going to get all of them in, I'm afraid, and we will try to answer any of them separately afterwards. But if I could just ask you a couple. First of all, we've got a question around, you've given us a good review of what's in the Act. What's missing? Is there anything that you would have hoped to see in the Act, or that's not made it at all, or that's been lost in the drafting?
I guess that's inevitably there always will be, and everybody would have their personal view on that. I think one of the ones that stood out for me was the fairly weak, one might say, clauses on the use of plastic and how we were going to deal with waste and with plastics. I think for the moment, just having take your bottle back and get 10p back, or whatever it's going to be, that we used to do as kids, that doesn't seem to really tackle it. And I noticed that recently our Prime Minister said that recycling didn't work. So I think having those two things combined worried me a little bit. I think having, to a certain extent, it was always going to be the case, but I think having the lack of teeth and independence of the OEP is yet to be proven. I know that everybody thinks it will be okay, but at the moment I think the funding of it is from direct government, central government, and so I do worry that it might end up being a little bit stuck the same way that maybe some of the SNCOs have been in the past.
Absolutely. Yep, I agree. And I'm also old enough to remember bottle recycling, though there were glass bottles in those days. But yeah, nothing on microplastics really, is there, or vehicle tires and so on. So yeah, I think I'd agree with those areas. I got another question around, as ecologists, most of the time we're talking about things like the Wildlife and Countryside Act. Is the Wildlife and Countryside Act affected in any way by the Environment Act? And are we expecting any changes there to things like protected species legislation?
Yeah, it's a good question. I think the quick answer there is that the Environment Act has no influence on the Wildlife Countryside Act. That legislation is still there and still enacted and being used. I think from an ecologist point of view and a conservation point of view, I would like to see further legislation, or at least revised legislation of the Wildlife and Countryside Act. I think when I talked earlier about some of our current protections and legislation being not fit for purpose anymore, I am largely thinking about the Wildlife and Countryside Act. The obvious thing to pick on here is the schedules of protected species that largely stuck in the mud. There's lots of, obviously I know about birds, and there's lots of birds on that list that shouldn't be on it potentially, and there's certainly lots of birds that aren't on it that should be. So I think revising the Wildlife and Countryside Act is going to be the next sort of cab off the rank from my point of view. And I know that there's a quinennial review that's taken place, and that's going to be in consultation soon. But I think that we can dovetail in a fit for purpose, modern, dynamic wildlife species protection legislation that dovetails in with the Environment Act, and then that would be a really powerful piece of dual legislation.
Thank you very much. I've probably got time for one or two quick ones. I've got a quick one here. When does the 10% net gain for biodiversity requirement actually kick in? And a kind of related one, if you like, to that, who will make the judgment that 10% gain has actually been achieved?
A good question. The net gain, the mandatory net gain, is going to rely on secondary legislation. So to a certain extent, the timetable is dictated by that. But I think I'm right in saying, and stuff you probably know better than me, that we're going to be looking at 18 months from now, so that sort of timeline.
Yeah.
Who judges this at the moment? It's going to be down to the local consenting authority. But as I said in my talk, the resource to enforce that and to monitor it almost certainly isn't there. So I think there is a bit of a gap, and a bit of a worrying gap there with how this is going to be played out. I'm confident it will be resourced, and it will be, that sort of gap will be closed. But at the moment, we're still sort of second guessing on that.
Yeah, absolutely. Thank you very much. There are so many more questions, but I'm not going to be able to get to them all. I'm going to ask you one more because we're just about on our time limit, and that is one of the areas of government that's exempt from the requirements on public bodies is the Treasury. How does that square with lots of the other commitments that are being made, and documents like the Dasgupta review?
The quick answer there is not very well, isn't it? It does seem, as I said, I think the MOD bit I sort of understand, as much as I understand anything about the MOD. But the Treasury is a worrying one, because I think the signal it sends to me, or to my mind, is that money will trumps everything. It's very nice to have all this legislation, and we are, the rhetoric round about what we're going to do and leave it in a better place and so on. It's great, and it should be applauded. But push comes to shove, money's going to trump it, and I don't like that. And I think that's what needs watching, in my view.
Brilliant. Thank you very much, Tim. I haven't really got time to take any more questions now, but we will try and reply to you individually with responses to the questions that are still outstanding there. Just to remind you again that we will be sending out a feedback survey about an hour or so's time. It'd be really great if you could respond to that and give us some help with the sorts of things that you'd like for future webinars. Our next topic is called Life on the Road, the Biodiversity of Highways, and that's on the 3rd of February with some of the RSK Biocensus team. So all that remains for me to do today is to say thank you very much, Tim, for an excellent talk. Covered a huge amount of ground, so I'm sure it's been really helpful to all our listeners. Thank you all for dialing in today, and see you next month. Thank you very much.
Thank you.